Welcome everyone, and thank you for participating in today's webinar hosted by the National Latina Network for Healthy Families and Communities, a project of Casa Esperanza that builds bridges and connections among research, practice, and policy to advance effective responses to eliminate domestic violence and to promote healthy relations within Latino communities and families. My name is Jose Juan Lara Jr., team member of the National Latina Network and your host for today's webinar, Enhancing Cultural Responsiveness in the Courts webinar series in partnership with Center for Court Innovation. This three-part webinar series will focus on enhancing access to justice by fostering more culturally responsive courts, court staff, and judges, identify role-specific responsibilities in implementing culturally responsive practices in the courts, assess culturally specific barriers survivors may face in the civil, family, and criminal justice systems, and design strategies for overcoming those challenges. Session 2, Court Culture and Access to Justice. This webinar will explain the concept of court culture and how do cultures have their own culture. What are the characteristics of court culture, and how can those qualities help or hinder litigants on domestic violence cases, both petitioners and respondents? But before we start, a few housekeeping details. Participants have been automatically placed on mute. As an extra precaution, we ask you also do the same. If you're joining us using an agency phone and have hold music, please be aware it will be heard if you, for some reason, need to put the call on hold. If you have any questions, please submit them in the Ask a Question box on the lower right-hand corner of the screen. We will also be providing closed captioning. This webinar will be recorded and uploaded to the National Latina Network website. Any resources mentioned will be sent to participants and receive an evaluation after the webinar. We ask that you kindly complete the evaluation since this helps in shaping future content for our webinars. If you'd like to register for the last webinar in the series, you may go to nationallatinanetwork.org. With that, I'd like to welcome our presenters, Honorable Rosa Figueroa, Judge of the 11th Judicial Circuit, Miami-Dade County, and Liberty Aldrich, Director of Gender-Based Violence Programs at the Center for Court Innovation. Welcome, Judge Figueroa and Liberty.
Thank you.
Thank you, Jose Juan. Hi everyone. This is Liberty Aldrich, and I'm very happy to be here with you all today. At the Center for Court Innovation is a national technical assistance provider with the Office on Violence Against Women. That is the comprehensive provider for the Justice for Families program grantees. I'll be interested to hear how many of you are affiliated with Justice for Families grantees or other grant streams. And in that capacity, we've been working with courts across the country since around 2006 and with other system-based responders to domestic violence, including prosecutors, defense, civil attorneys, supervised visitation providers, and others on improving and enhancing response to their families. And in particular, we have worked in collaboration with CASA and others around the court's response to and ability to improve their response and become more culturally responsive to the diverse families that need their services. So I will just say one more word about myself. I'm an attorney, and before joining the Center for Court Innovation was practicing representing survivors in family, immigration, and divorce matters in New York City, where I still live. And with that, Judge, do you want to introduce yourself?
Sure. My name is Rosa Figueroa. It's a pleasure to be here with you all and share this time with you. We hope to impart some good information on being more responsive to the litigants that come before us. Just by way of introduction, I sit in Miami, Florida in a unified family division where I deal with cases of families afflicted with violence, independency cases, child abuse, as well as high conflict dissolution of marriage cases. And before that, I was in a dedicated domestic violence court and worked as a public defender for many years. So it's my pleasure to be here, and we welcome any questions that you all may have. And we hope to be able to provide you with a format to be responsive to the litigants and all their diversity that come before you.
Great, thank you. With that, I'm going to just quickly introduce the learning objectives, which the judge already mentioned. I think we want to spend some time just talking about what we mean when we say court culture, and then want to hear from you around what you think your court culture is. And so we're hoping as much as possible, given the format of the webinar, that folks will participate in a sort of interactive process with us and chat with us through their chat boxes. And so if anyone has any questions about that, please let us know. But hopefully we will get lots of responses on the chat box. And then finally, we're going to spend quite a bit of time talking about the concept of neutrality and how that factors in when we're talking about courts and cultural responsivity. Judge, any additions there?
No, just that I want you all to kind of think about what neutrality means as we go through this process. That's it.
Great. So what is court culture, or at least what do we mean by court culture? And we know that the session number 3 that in this webinar series is going to spend some more time defining culture in general and what does that mean, and it's a difficult term. But what I think we are trying to ask all of us on the phone to look at before we start thinking about, oh, what are the other cultures that we should be responsive to, we want to understand ourselves where we're coming from and where your court may be coming from if you're not a court person, but you're a stakeholder, just trying to spend some time thinking about the culture that we may take for granted that exists within the courthouse and the legal community that surrounds it. So we think about court culture as akin to any type of workplace culture, which affects the way the organization runs itself and how we think about staff performance and what the underlying assumptions are around what the goals of that institution and workplace are. So when we talk about court staff, again, we're thinking about judges, court administration, court clerks, attorneys, security, and also to some extent the service providers that may be co-located in the courthouse. Often court culture is affected by the leadership of the court, so judges, court administrators, and others, and may depend on the type of jurisdiction that the court is in. So obviously criminal, family, civil, but also rural or urban areas. All of those things will have an impact on the court culture. But there are nevertheless some common threads that we think we want to highlight around what are some common ways that court culture expresses itself. And then talk about what the impact on litigants is of that court culture. So before the judge and I might spend some time talking for a minute or two about the court culture in our locations, but we wanted to ask you if you could, in the chat box, just how would you describe your court cultures? First, we're just going to take that first question there. How would you describe your court's culture? Also, that's difficult to say many times fast.
Yeah, and when you think about that, Liberty pointed out some of the physical characteristics, and it can even be whether there's a crowded calendars, caseloads, anything about the administration of these cases would impact the culture.
So I see a few people typing, which is great, and I hope others will join them. Although I'm not seeing any actual words appearing on the screen.
Not sure. Yeah.
Also, I know a few people on this, so I'm not above calling on people.
Well, we have multiple attendees typing.
Okay.
I don't see anything yet.
Marissa, just want to make sure that you think this is working.
Well, here we have rural type state, close quarters, small town, people know each other, shared judges within a district, full calendars.
Thank you, Bridget. Yours uploaded first.
Yeah, overcrowding, a lot of overcrowding.
See a couple more people typing, so we can just give a few more minutes before we
What does me deal with a case overcrowded jail and large calendar? These are some great responses.
Yeah, this is excellent. I hope in the recording of this, Marissa, there's a way to capture not just the verbal stuff, but the notes.
Yeah, because we even have some comments where, given the nature, then there was a response, given the nature of the problem presented, there was a response to it in Ferguson, or after Ferguson.
Great, thanks Marissa for the update. The chat box is also being recorded. All right, so I think we got a few answers there, and actually I'm going to jump to the next slide and then go back to the second question on that activity sheet, because I think so many of you mentioned a couple of the common themes that we hear when we talk about courts, which are the overcrowding. So one, whether it's a rural or an urban environment, we see that consistently, that it's very busy, and often people are playing multiple roles or running from one courtroom to the next. As I mentioned, I practiced in New York City, which, everyone thinks, oh, all the New York City folks think, oh, our courts are so busy, but I always point out to them that actually sometimes rural counties have more cases per docket. But no doubt in urban counties, the sheer number of people is often overwhelming and presents a substantial challenge to just management. So one of the things that I think, I would say about the New York courts culture is that it's chaotic. And even though everyone thinks that they, the folks who are in it may know the rules and know how it's working, the perception to an outsider is sort of confusion and a little bit of chaos. But I think that one of the points that we wanted to talk about in terms of the values that many courts hold, and some of it's as a result of this busyness, that courts often define themselves and success by efficiency. So one of the major things that they are looking to do is to be efficient in moving cases forward. So many judges, and I don't know if this is true in Miami, but many judges or courts measure time to disposition. They measure how long cases are in front of a particular judge, and all of that can, there can be a lot of pressure put on everyone based on that goal of efficiency. Judge, I don't know if you have any experience.
Yeah, no, I agree with that completely, and I'm sure that many of you doing this kind of work know that in cases dealing with complicated family issues like domestic violence, it's very difficult to gauge them according to the time spent. So what we had here in Miami when we formed the Unified Family Court, that we had all these domestic violence cases, was that the judges here were being measured by the same measurement of time spent on cases that the other judges, either in just dependency or just family, were dealing with. And it does. It creates an intense pressure, and that creates a culture that does not bode well, I don't believe, for litigants dealing with these kinds of issues. Absolutely. And I also wanted to make mention that I see a lot about diversity and communities dealing with diverse communities, either because of multiple languages or different countries of people. And I believe that's another thing that we deal down here. Of how do you deal with families that may not speak English or may have other values that maybe are not mainstream, or other traditions that are not mainstream, better said.
Right. So, and we're gonna definitely come back to that as a major theme. But just to go quickly through some of these other kind of core values, we're going to spend a bunch of time on the bias and neutrality. So we're going to, I want to leave that aside. But understanding that courts are also driven by the idea of precedent. So what happened before is what drives what happens now, which again is that's a cultural value that courts have that may not be shared by other members of the community. They may not, folks who are coming to court may not realize that the court is thinking about, well, this is what we've done for so many years, therefore that's what we have to do now. Additionally, they're very paper-driven, which again, whether it's electronic filing or not, they're very driven by what is written down. So many courts, you can't do X because the paper is not in order. And again, that is a very core assumption and value of what drives court process, which may present a significant challenge to folks, as the judge just said, who may have different language needs or abilities or contexts. And clearly, that's a challenge in interacting with the court system. We could spend several weeks talking about how courts think about victim safety and offender accountability, and obviously that's a highly difficult, challenging area, but I did want to mention for folks who are not familiar with it, the idea that BWJP and Ellen Pence and others talked about, which was that in our court systems we often have sort of 3 different planets, and when they talked about that, she was talking about that the cultural understanding of domestic violence is very different in criminal courts, family courts, and child protective proceedings. So in family courts, the sort of underlying assumption about domestic violence may be that it's an issue between 2 people. In child protective proceedings, the sort of underlying assumption may be that parents should be protecting their children from exposure to domestic violence. And in criminal court, the underlying assumption may be that there's a perpetrator and a victim, and that those 2 things are not overlapping and or shouldn't be confused. So those are very different kind of underlying assumptions around both victim safety and offender accountability that may exist in different parts of the court system. So we wanted to go back to this question about understanding the impacts of court culture and who does it work for and who does it not work for. And so there's now, I see a typo in the slide here that I wrote. Sorry about that, folks. But so we're asking, what were the common assumptions about litigants when your court was created, about judges and their role, and how do those assumptions impact current litigant experience? So I see folks have continued to type into the chat box, but now we're adding another question if folks are willing to respond to this. Sort of help us think through what the understandings originally were, who the culture works for, and for whom does it present a significant challenge.
So if you all can just think about when it was done, what were the assumptions about who was going to use the court?
I see some folks are typing. I also see, by the way, I love to see when folks are mentioning that a grant assisted them with providing more assistance with forms and resources in the community to DV survivors, which is excellent. And Tracy from Texas mentioned that there's a lot of diversity in court culture in Texas, which Texas having more courts probably than anyone else. I not surprised. I think it presents a big challenge to those of us who are working with the court that there is diversity, because sometimes we bring expectations from one courthouse to another that may not be the same.
That's very true. And even when you're in a jurisdiction with diversity, your set of diversity may not be the kind of diversity that's in another jurisdiction, right?
No. I'm not sure if folks are trying to type in. I see Bridget is trying to type. Ah, there we go. So some of the challenges that Bridget mentions, being able to address court outside of the process, or a lack of clarity around how that interaction is supposed to happen. The time that it takes is a significant challenge for those interacting with the courts, and the difficulty for pro se litigants. So one of the assumptions that people had about litigants when many courts was created was that everyone would have an attorney. I mean, that was kind of the model was a little bit of a civil model where there were corporations or people had an attorney and people had funding because only certain people were accessing the court, and those folks had attorneys. So some assumptions around who the litigants were supposed to be when courts were originally set up were maybe substantially different than who is accessing the court now.
Or even the kind of issue. Maybe when it was created, there were some issues that were not really thought of as being addressed by the judicial system.
Definitely.
Intimate family issues may not have been.
Yeah. I don't think anyone, when they were thinking about it, was thinking that family, intra-family issues would be the focus of the court system. That was for maybe faith leaders or neighbors, but the court was primarily thought of as addressing issues between public entities.
Right. Or even what the community looked like. We have some more typing.
We'll just give another minute for the folks who are typing for your things to appear. Seems like it, when multiple people type, it starts, maybe it doesn't know how to handle that. Lots of people are writing like books.
Good.
All right, well, I'm mindful of time, so I'm going to go on to the next slide. But, oh, there, Deb, your comment just showed up. Yeah, Deb brought up the very common cultural understandings around domestic violence, which have to do with why don't victims just leave, and that what the role of the justice system is in that. Mary brought up the issue of diversity on the bench, both gender and racial or diversity, which is I know a common issue across the country. So we were going to spend a few minutes highlighting what some of the barriers are that litigants may experience in accessing the courthouse. Many of them have already, you've already highlighted some of them, but we can go through this list. We could do an entire session on language access, and in fact, we may add one on, or there are other sessions that we've hosted webinars on language access in courts. And for those of you who have never visited, I'm going to type something into the chat box, a website that is for anyone who's interested in looking at language access rules. I would recommend that you check out lep.gov, which has lots of resources on language access and the rules around language access, especially for courts. Judge, is there anything you want to add about language access?
No, I think that that's a pretty comprehensive list. Just that remember that it can come, language access, I think I would want to impart on people is just important from the minute that they walk in the door. Whether it's that there are signs in the courthouse, to the language on the forms, to the ability to be able to get your message across to the judge.
Absolutely, and yeah, I was just on the phone this morning with folks from Minneapolis, and they are adding 2 Native American languages to the signs in their courthouses, because while you know, we think of state courts as maybe not serving tribal communities, obviously many folks do need to access state courts, and so being comprehensive and thinking about the language needs of the litigants who come to the courthouse is really, really important. I see Esra is talking about many courthouses don't have interpreters the same day, and this is a huge problem, obviously, in terms of getting emergency protection orders, because it's very difficult for courts to be able to know who's going to come into court for an emergency protection order. There are lots of efforts around the country trying to address that through the use of language line or other facilitated access, remote video interpreting, or other strategies. So I would ask if anyone is interested. We're absolutely happy to follow up with some of those strategies, but for sure it can be a substantial challenge to access courts when you need an interpreter. Cultural views, we've talked about that. Some of the cultural views that courthouses may share around the litigants that they see. Some concrete barriers, of course, childcare and courthouse safety, what do people expect when they come to the court around, are they going to have to see the offender? Are they going to have to spend time with them in the waiting area, in the parking lot? All of those are substantial barriers. Of course, religion, immigration, education, economics, all of those may present barriers for folks feeling that they are welcome and able to truly access the services that they may need from the courts. Judge, do you want to mention any of those in greater detail, maybe immigration challenges or any other thoughts on that?
Yeah, with regards to, I do, Liberty. With regards to the immigration challenge, I think that the threat of the immigration challenge can't be understated. I think there are a lot of communities dealing with the whether communities are safe haven or not, and regardless of what happens in the actual or what the authorities in a community may say, I think that we all need to be mindful that the immigrant community is a very verbal community in the sense that news travels through the grapevine, and it's important to note when dealing with a community that's marginalized due to immigration issues that there may be a course of conversation that the rest of the people outside of the communities may not be privy to, and that is a very strong influence in whether to seek help or not. So I think that's important that when we deal with these and we talk about access to justice, that we keep that in mind.
Thank you. So I don't know if anyone wants to type anything that we missed. Obviously, there are a long list of barriers that may exist either in your community or that you're familiar with. And we would be, this is not necessarily the full list. So if anyone wants to add a barrier that you're familiar with from your community, please do so that we can share that with others. But we're going to go on to the next section, which is thinking a little bit more specifically around this idea of neutrality. And the judge is going to help us think about that.
So I want to pose the question about what is neutrality. My screen went blank. I don't know if yours did, but my screen went blank, so I'm going to have to rely on you all. Can you all hear me?
Yes, Judge, we can hear you, and I think maybe they're getting ready for the video. But go ahead.
So I am going to invite you all, if you can, in your chat box, indicate some of the issues of what you think of when you think about whether a court is neutral or not. Let me see some things. Just what neutrality really means, and what neutrality would mean in this. In our office that are hesitant to speak. All courts should be neutral. So let me just see what these comments are, and then we're going to. So Mary put in a statement, all courts should be neutral, regardless of culture, that you can come into a room with a bias, but all people, regardless, come with a room with a, but all people, sorry, regardless of culture, come into a room with a bias. I think these are all very common issues that we think of when we talk about neutrality and what it means in a courtroom. There is a perception or a desire that it be neutral. Sometimes people talk about not just calling sides, not only taking a side. Let's see, Neutral is when both parties have a chance to be heard, not only the side that has an attorney. A survivor may believe that the court is not neutral based upon police response. So I think we can all agree that neutrality would mean fair and impartial. And I'd like to start by reading to you something that is how the Center for Justice, the Brennan Center for Justice in NYU, defines what a fair and impartial courts are. And that they are the guarantor of equal justice in American constitutional democracy. The very legitimacy of the courts depends on what the public belief is that the judges will treat each party without bias or favor, and that any party, regardless of wealth or connections, can have a fair day in court. I think we could all kind of agree to that kind of definition of what a fair and impartial court is. And so I want to start by sharing a clip with some quotes from two justices from the Supreme Court, Justices Breyer and Kennedy. And when they made these comments, they were actually talking about campaign contributions on judicial elections. But I believe that their comments really transcend that topic and speak to a much broader review of justice, which I believe to be really important for us to consider when we talk about neutrality with regards to domestic violence cases. So if we can play the video.
Independence doesn't mean you decide the way you want. Independence means you decide according to the law and the facts. And pretty soon you'll have a clash of political interests. Now that's fine for a legislature. I mean, that's one kind of a problem. But if you have that in the court system, you will then destroy confidence that the judges are deciding things on the merits. And if people lose that confidence, an awful lot is lost.
I do not think that we should select judges based on a particular philosophy as opposed to temperament, commitment to judicial neutrality, and commitment to other more constant values as to which there is general consensus.
I mean, isn't the verdict in from the people that they cannot trust the judicial system there anymore?
This is serious because the law commands allegiance only if it commands respect. It commands respect only if the public thinks the judges are neutral. And when you have figures like that, the judicial system is in real trouble.
And when you have figures like that, the judicial system is in real trouble.
So I'm assuming that everyone's done with the video. One of the things that I think is very impactful in what they're saying is that the law only commands respect if it's neutral. And that the key to having a neutral court is applying the law to a set of facts. And that's a very powerful statement in my view because it kind of begs the question, can the courts be culturally responsive in domestic violence cases and yet remain neutral? Or does being culturally responsive mean that you are no longer neutral? And how do we apply the principles enunciated by these justices within the framework of being culturally sensitive and addressing some of the issues that you all have raised here on the side without being perceived as being activist or favoring one side over the other? I would suggest to you all that it's not only inconsistent, but it's imperative. Because the key to the work that we're called upon to do is to get to what the facts are and to apply the law to the facts as they are. So if we have to get to the facts, you don't know what the facts are if you have these barriers that are impeding your ability to see the facts. So when we look at that, I'm going to put up. We start looking at the factors that comprise finding out what the facts are. We look at people that, as you all have raised on some of these comments very eloquently, point out that the litigants are individuals, and applying the law with neutrality requires that we apply it fairly to each individual. They come into court with very many experiences. So I ask you, in some of the jurisdictions that have diversity, does a Latino woman that was of Puerto Rican descent that maybe grew up in New York, is she going to, although she's Latin, is she going to have the same issues walking into that courtroom as a woman who fled Venezuela because the Venezuelan market is gone, where kids are roaming the street in gangs and fighting over turf wars with regards to the nature of the restaurants are located in an area because they can get better food out of the garbage. The same thing can happen if you are dealing with an African American from New York City, perhaps, as opposed to somebody that is African American and living in Minnesota or Wisconsin, or a Haitian living in Miami. All these litigants are going to be coming in through that courtroom door with all kinds of different experiences, and recognizing those experiences is going to be critical in determining what the facts are in that case so that the law can be applied. We also need to look at issues of inherent privilege. And I'm not saying that privilege is a bad word, but there are certain privileges, and one of the comments even brought that up, that come with just being part of the prevailing population in the community. So that white males or even females or education, language, economics are going to place those people in a position of privileges that others may not have. Therefore, their experiences are going to be different. There's also the privilege that the trier of fact is going to have when viewing the case. That can also be a barrier to really determining what the facts of the case are. Our failure to see all of that and how privilege might taint our ability to see the truth can be a real barrier towards neutrality in a courtroom if we're not careful of that. So perhaps a woman may not choose to come to a hearing because she's going to lose her job, and someone else might be thinking, well, if the issue of violence was so important, how could she not come to court? But unless you understand what the issues of privilege or some of these other issues might play, you may not be able to get to the true facts of whether there's violence there or whether those children need protection. Another issue when dealing with cultural responsiveness in a domestic violence case would be the fear of the courtroom experience. And if we visit our Venezuelan woman whose experience with government is going to be that government is a complete breakdown, her experience is going to be different than the woman of Puerto Rican descent that may have issues with the American justice system, but sees the government experience in a whole different kind of way, or the African American who's had different experiences as well. All these traumas these litigants bring to the courtroom, and the experience of being in the courtroom has a traumatic effect as well. So here I've seen some comments about how people feel coming into the courtroom, and that's a whole other layer that, unless we're aware of that, can act as a barrier towards seeking the truth. And it can be as simple as when you come in through the courtroom door, not being able to communicate with the security guard downstairs and not understanding that he wants you to do is take off your shoes so you can go through the metal detector. If we don't have a culturally responsive court system, what we get is a distortion of the facts and a distortion of the truth. And if we have that, then there is no promoting of safety, there is no healing, and you don't promote an environment in which you can excavate what the truth is of the cases. We would not want a survivor to believe that the court system is not neutral because they had a police experience that made them believe that because they were a marginalized community, the violence that they're experiencing and the violence of their children is not as important as anyone else. We would not want a woman who is in fear of deportation to think that she can't come and get safety for her children because she's afraid that an uncle or a brother might be deported. These are all the issues that we have to deal with when we create an environment where we can deal with the true facts of a case and be culturally responsive. And I think it's recognizing these differences that make us culturally responsive. One person's experience is not like the other, and trying to understand that is what gets us to the truth and applying the laws in a neutral manner. So whereas before we might want to say we're not here to take sides, we're not here to take sides. Or rather, we are here to take sides. We're here to take sides on getting to the neutrality, getting to the truth. And you can't get to the truth if you don't understand all the cultural differences of the community that you have in front of us. I don't, Liberty, would you like to add anything?
No, I think, you know, many judges wrestle with this question as a judge in terms of what questions can I ask from the bench, how much should I be asking or just waiting for people to present to me. But similarly, I think court systems, whether it's clerks or other service providers, can make sure that they're asking the good questions. We never want to assume answers. That indicates bias. But to ask questions intelligently, sometimes you have to think about what are the issues that that person before you might be experiencing.
And I think it's a commitment we all need to do. Obviously, the judges perform like a great leadership in the process, but it has to be the bailiff, the court clerk, the security guard, the clerk's office, everyone having a conscious commitment to being culturally sensitive to the litigants, so they feel welcomed and they feel that the courtroom and the access is a place of safety.
Yeah, I like, Lydia, your comment that neutral is when both parties have a chance to be heard. That's a critical thing. And for folks who are not familiar with the concepts of procedural justice and procedural fairness, but that opportunity to be heard and voice is a critical aspect of feeling any kind of trust in the outcome of the proceeding. So I think we wanted to spend a few minutes now talking about some of the practices that we've seen and that we've heard about folks mentioning. We are also very much welcome anyone who wants to add your examples of culturally responsive practices used in your courthouse. And I think the judge just really was mentioning the listening with no judgment is a critical piece. But I think we wanted to circle back on the first one and talk about hiring bilingual staff, which, you know, we talked a bit about language access. And there is a lot to be gained by making sure that folks, as people mentioned, you know, emergency protection orders, it's hard to ensure that there will be the correct language speaker at the security desk when someone comes in for an emergency protection order. But if many courts have been working to hire bilingual staff, and very importantly, to certify those staff as in the language. So it's one thing to say they're bilingual. We also know as courts that those folks need to be certified and may also need to have their role clearly defined so that they're not brought in inappropriately or, you know, end up serving all of the clients because that is not the goal. But certainly it can be a significant benefit if staff have other language abilities. And Judge, I know you have experience with that.
Yeah, I wanted to add, and don't assume, for example, that because someone may speak Spanish, that the Spanish translation is going to be accurate with regards to everyone. Different countries will have different phraseologies, and what might mean something for someone from Puerto Rico is not going to be the same for somebody from Mexico. So what I find down here many times is that, yeah, there's a Spanish interpreter. I happen to know Spanish, so sometimes even in the translation, I can tell if they're not translating what is meant by certain phraseologies. So when you have that about different languages, you have to be aware that different regions will have different ways of saying something, so that if you hear a victim or someone saying, well, that's not really what I meant, I'm not saying you should always believe that, but I think there has to be an ability to judge that statement in the context of the accuracy of the interpretation that was done.
So we have on here design a judicial script, and this is a sort of complicated one, and no one is suggesting that judges be absolutely limited to scripts, but there are common issues that may come up that a script can help create consistency between different courtrooms. So we can, for example, around linking litigants with advocates if they're not, or providing referrals to other programming for, whether it's batterer intervention programming or other things, so that some of the, strengths, some strong approaches can be written down in script and shared between different courtrooms. Or across courthouses. Deb is mentioning that in her courthouse, they were more inclusive by including flags and other things across courthouses, which is fantastic. I think treating people with kindness is absolutely critical, and when we think about everyone in the courthouse, thinking about customer service and how to treat all litigants respectfully is absolutely appropriate. Another strategy is that someone mentioned earlier is ensuring attorney access, and as much as possible. Obviously, attorneys are a very limited commodity, which we are very familiar with, but facilitating access to counsel, especially counsel that may be language specific, is a great thing to do. When we think about cultural responsivity, we also should be mindful that we are serving folks with that may have physical challenges accessing the courthouse, so installing ramps, elevators, and other things to assist folks with either physical or visual or auditory limitations or differences. Those are really important, and there's a lot of information for folks who are interested in knowing more about that. The Vera Institute runs hosts a site that focuses on serving domestic violence survivors who may have challenges around access, and so I would recommend folks check that out. Similarly, I think we talked a bit about speaking kindly, but also using plain English. That's a significant challenge in courthouses. And I didn't mention that at the beginning when we were talking about sort of culture, but one of the big challenges in courts is that the language that we use is often legal language and is not intelligible to the litigants. So as much as possible, making forms in plain English and speaking in plain English is very important. Judge, I don't know if you have anything you want to add on that one.
No, just that, and even not using abbreviations. How many times do we all use abbreviations that we're so used to, and somebody from the street has no clue what we're talking about? And that can add to the confusion.
Absolutely. We see often that court staff do not receive training on domestic violence. So while Deb mentioned the Judicial Institute on Domestic Violence, and that's been a fabulous resource, but very often court clerks or security guards or others do not receive the same level of training on domestic violence and on cultural responsiveness. And the center is working with the National Council on Juvenile and Family Court Judges to develop a sort of similar training to what judges have been able to access for court leaders, but it's very critical. Miami has always been a leader in this, in developing training and other access to information for other folks in the courthouse. We haven't talked a lot about being responsive to folks with who may be gender nonconforming, but that can be a significant challenge in our courthouses. And obviously, maintaining confidentiality is so critical in domestic violence cases generally, but also in cases involving folks from different cultures, that can really increase the trust that folks may have. As the judge just mentioned, they may come from cultures where there is no confidentiality, and so that is something that can make a big difference in their ability to access the court.
Absolutely.
So, I don't know if you're about to say something, Judge.
No, I'll let you finish. I just wanted, just in general, Liberty, I wanted to point out, because that comment about just being kind, if you really think about that comment in the context of all these things that you're pointing out, it makes so much sense. Because all of these issues, just with giving that kindness when you approach someone, whether it's doing forms that are more open to other stakeholders, maintaining confidentiality, listening with no judgment, avoiding generalization, could come under the aspect of just each stakeholder and each person in the courtroom trying to be kind to the person in front of them. And that was the only comment I wanted to add.
For folks who are interested in pursuing this, and Deb mentioned, their efforts to be more inclusive for members of their community from their local tribal areas. I think they are a great example of somewhere that really spent a lot of time thinking and sort of doing walkthroughs, auditing the courthouse to see where the challenges are, where they could be doing better. And so one thing that we often recommend is that people do a walkthrough and pretend, or get folks from different communities to come with them, but think like, okay, I'm going to think of myself right now as a non-English speaker. What would the challenges be if I were trying to access the courthouse? So we think that's a really helpful strategy that folks can use. And then recognizing bias, we assume that we're not talking about intentional bias here, but we're talking about things that may not be obvious, but where, again, based on common assumptions that may have been true a long time ago, certain practices develop. So again, whether it's that all the signs are in English and so it may not be accessible to others, or whether it's that certain criteria for certain programming, all these things that we may take for granted may end up with folks having that be a challenge to accessing the services that they need. So those are some of our ideas. I don't know if anybody wanted to type some more thoughts, but we also wanted folks to spend a few minutes just thinking to yourselves and hopefully typing in how you might, within your specific role, if there are any things from this session so far that you could think about how you would incorporate that in your specific role. See, folks are typing, so we're going to, as usual, wait a few minutes and see what folks come up with.
That's a good one. Foster relationships with court departments.
Thank you, Elizabeth. I think it's domestic violence counselors and advocates provide a critical role facilitating access. So just as much as possible, being able to find ways to engage with court players, whether it's the judiciary, court staff, or attorneys or other system-based providers, and beginning to think with them around how to work together to respond to the challenges that you all identified and that we identified.
And I just wanted to add, piggyback to Liberty's comment, because I think sometimes I hear comments that the judges are too far apart or they just don't understand, and sometimes we all know that can be true. But Liberty's comment to try to see how you can partner, I think judges might be more receptive or can be very receptive to hearing somebody from a counselor saying, judges, you don't know what it's like when this and this happens. And I think that brokering that conversation with all parties is very important, especially if you notice as someone on the front lines that the access just isn't there and the cultural sensitivity just isn't there. I think sometimes if people realize what's happening and are forced to see it from another point of view, you'd be surprised at what can happen.
Yeah, I mean, just to piggyback on that, you know, I've done walkthroughs with head court clerks who have, you know, not done a walkthrough from the front end as a potential petitioner for a long time in their own courthouses and systems. So even just doing that sort of walkthrough can make a big difference.
Right, because it starts changing that culture.
Yeah.
Sorry.
No, that's fine. So training on cultural responsiveness in DV cases, that's great. I hope other folks will be interested in that. we're planning to, we thought we would wrap up around now and see if other folks have questions for us. And I know it can be hard to ask questions on this, but if folks do have questions, please, please ask us. I see Mary is typing. So we'll see. If anyone else has questions or things that they want to share about their role. You guys have shared a lot, and we really appreciate all the comments in the text box. So I think that worked very well. Thanks to you all. I know Jose Juan is going to wrap up and talk about technical assistance from their end, but if other folks have questions, I'm going to type my email into the chat box, and we would also be happy to, if folks have particular questions about the presentation.
Yeah, I'm also going to do the same. I wanted to thank you all for sharing this time with us, and you know, even if we don't solve all the issues, I think that just being able to address and sometimes sit down and doing very minimal things, you'd be surprised at how you can change a culture in a courtroom or a court process.
Thank you, Judge Figarola and Liberty. And as Liberty mentioned in the early part of the webinar, this is part of a project funded under OVW in collaboration with Center for Court Innovation, and other national TA providers as well. So if you all need any kind of additional TA around enhancing cultural responsiveness within the courts, please feel free to reach out to us. We will provide contact information when we send out the evaluations and then whatever resources that were mentioned during this particular webinar. Again, if you have any questions, please feel free to contact me at my email at jjlara@casadeesperanza.org. Again, thank you, Judge Figarola and Liberty, for sharing your knowledge in this webinar, and thank you to our participants for joining us here today. Also, stay tuned for the last webinar in the series, which will be happening in May 19th, I believe. We will send out more information on that as well, along with the evaluations and then copies of the presentation. So with that,